Syahadah or testimony, the first source of the proof of any fact in Islamic law, literally means information of what one has witnessed or seen or beheld with his eyes, declaration of what one knows, decisive information, the statement of a witness of any matter, oral or written, in or before a court to prove or disprove any fact disputed. Conditions for a witness. A witness must be adult and sane, which his evidence shall not be admissible. This is the unanimous view of the jurists of all schools of thought, based on hadith of Holy Prophet said, 3 persons have been exampled. First, the minor until he becomes puberty, the insane until he attains sanity, and the sleeping person until he awakes. A witness to be adil or credible. Adil means one who acts equitably, justly, or rightly. Legal terms means a person of irreproachable and serious character who is not liable to suspicion. A witness to be a Muslim. A witness must be Muslim, and as such the Syahadah of non-Muslim is not admissible, neither for and against a Muslim nor for and against a non-Muslim. Testimony of a woman. A witness in hudud and qisas must be male, and thus the testimony of a woman is not admissible in hudud and qisas. A witness in hudud and qisas must have eyesight and power of speaking. A witness must possess the power of saying and faculty of speaking. Blood relation is not admissible. Enmity. Majority of the jurists agree that enmity between a witness and a party in the same case disqualifies the witness and renders his testimony inadmissible. Numbers of witness. 4 witness. The offence of zina, adultery or fornication liable to had is proved by the testimony of 4 witness. 2 witness. The offence of murder and hurt liable to qisas, and the offence of theft. 2 male or 1 male and 2 female witness. The testimony of 2 men or 1 man and 2 women has been mentioned in the Holy Quran in connection with the written evidence of deferred debt.
1 witness and the oath of the claimant. It has been related that Holy Prophet has accepted the testimony of 1 witness endorsed by the oath of the claimant in support of his claim. 1 witness. Though Islamic law has prescribed 2 witnesses for the proof of an offence other than zina or a right dispute in a court because testimony of 1 witness is doubtful, but when it is supported by another witness, it becomes reliable. Conditions for the admissibility of testimony. Conformity between the testimony and claim or complaint. The contents of the testimony must be in conformity with the fact mentioned in claim or complaint, and there should not be any substantial contradiction between them, failing which the testimony shall not be admissible. Testimony to be relevant must related to the fact which existent or non-existent has been disputed in the court of the fact which are relevant to such fact. The forum. The witness of adultery must present their testimonies at the same legal session. Prior claim. Prior to giving testimony in offense which relate to the right of human beings such as qisas, diyat, had of qazaf. The testimony must be before or in the court. It is necessary for the testimony that it should be given before or in the court presided over by qadhi or judge.
Tazkiyah al-shudud, examination of witnesses, means the mode of inquiry adopted by a court to satisfy itself about a witness whether he is adil, credible or not. Two kinds of tazkiyah. Tazkiyah siriyah, secret inquiry, that if the court is not satisfied of a witness as to being adil, credible, it may, through a confidential letter addressed to two muzakis, seek their opinions regarding such witness as to his being adil or not. Tazkiyah alaniyah, open inquiry, is concerned. Its mode is that court may call two muzakis to the court and ask them before the court in the presence of the witnesses as to whether this witness is adil or not.
Do you hear me? I'm talking to you.
Confession. Confession is a statement, oral or written, made by a person accused of an offense, stating that he has committed that offense. Condition for confession. The person who admits or confesses must be adult and sane. Confession of a minor, insane, sleeping person or intoxicated person is not admissible. The confession must be explicit as to the commission of the crime and violation of the right. Any ambiguity in the confession renders it inadmissible. The person who confesses must be capable of self-expression. Imam Malik, Imam Shafi'i and Imam Ahmad said, the confession of a deaf and dumb person is admissible provided he can write his confession or his signs are intelligible. Imam Abu Hanifah said, his confession is not acceptable in hudud. The confession must be with free consent without any pressure or compulsion. Quantum of confession. Imam Abu Hanifah and Imam Ahmad. It is necessary in the case of zina to have 4 separate confessions, as 4 witnesses are necessary for its proof by testimony. Imam Malik and Imam Shafi'i, only one-time confession is sufficient in all offences including zina because confession is an information and does not need repetition. Imam Abu Hanifah, confession must be repeated in 4 different appearances even though within the same sitting. Addition, if a person confesses to have committed theft, hudud will not be implemented on him until the victim files a complaint against him. Confession proves guilt and incurs penalty only when the judge is convinced of it. Confession of co-accused. A confession is a proof against the confessor only and it is not a proof against his co-accused.